Hello and welcome to I Enhance Student. I Enhance Student is a segment specially designed for students who opt their topic to their research, present them in front of our audience. So let's welcome our today's student, Mr. Shubham Gaglani from KES Shri Jayanatilal H Patel Law College, who is going to enlighten us on his research topic, that is mortgage under Transfer of Property Act 1882. So let's welcome Shubham.
Hello everyone, my name is Shubham Gaglani. Today I will be taking through a very important topic under the Transfer of Property Act 1882, the concept of mortgage. This discussion is specially meant for law students and young professionals to help them understand mortgage in a simple and practical way. We will look at the meaning, the types of mortgages under section 58 of the Act with examples and some landmark case laws. By the end of this session, you will have a clear picture of how mortgages work in law as well as in practice. So let's get started. Now, before we go into sections and technicalities, let's keep it very simple. What is exactly a mortgage? In simple terms, a mortgage is nothing but a way of taking a loan by keeping your immovable property as security. You must have heard about housing loans, commercial loans, or even loans taken for business finance, right? In all these cases, mortgages are at play, and that is why understanding mortgages is not just important for you as law students appearing in exams. It is equally important for young advocates and professionals because mortgages are the backbone of property transaction and banking law in India. So today I'll explain this in a very simple and structured way. We'll first look at the definition, then the types of mortgage under section 58 of the Transfer of Property Act 1882. And finally, I'll also share the relevant examples and some landmark case laws that you will not only understand the concept but can also apply it in your exams and practice. Alright, let's begin. Now let's look at the definition of mortgage under section 58A of the Transfer of Property Act 1882. It says a mortgage is the transfer of an interest in specific immovable property for the purpose of securing payment of money, advance, an existing or future debt, or the performance of an engagement that may give rise to a pecuniary liability. Now let's break this down in simple words. First point, mortgage is only transfer of interest, not ownership. The ownership always remains with the mortgager, though mortgagee always only gets a limited right as security. Second point, the subject matter must be immovable property like land, houses, flats, or buildings. Third point, the purpose is always securing a loan or debt. And now, the parties. The mortgager is the borrower and the owner of the property. The mortgagee is the lender. The money borrower is called mortgage money. The document is called a mortgage deed. Now, in important case, Narandas Karsandas vs. S.A. Cantum 1977 Supreme Court. The Supreme Court held that a mortgage is essentially a transfer of an interest, not ownership. And very importantly, the mortgager retains the right of redemption until the property is actually sold or foreclosed. So the essence of section 58 subsection A is simple. A mortgage is a security transaction, not a sale. The borrower remains owner but gives limited rights to the lender until repayment. Essentials of a mortgage. Now let's look at the essentials of a mortgage under the Transfer of Property Act 1882. Now let's look at the essentials of a mortgage under the Transfer of Property Act 1882. From section 58 subsection A and judicial interpretation, we can identify 6 key essentials. First, there must be a transfer of an interest, not full ownership stays with the mortgager, only a limited rights goes to the mortgagee. Second, the property must be immovable. That means land, houses, building, not movable assets. Third, the transfer must be made to secure a debt or loan. So the whole object of mortgage is to security for repayment. Fourth, the parties. The borrower is the mortgager and lender is the mortgagee. Fifth, there must be a debt, whether existing or future. Without debt, there can be no mortgage. Now let's start with the first type of mortgage, that is simple mortgage, defined under section 58 subsection B of the Transfer of Property Act 1882. In a simple words, in a simple mortgage, the mortgagor does not deliver possession of the property. Instead, he personally binds himself to repay the loan. If he fails to repay, the mortgagee can approach the court and the court may order the sale of the mortgaged property. Ownership continues with the mortgagor until such sale. Let's take an example. Mr. A takes a loan from a bank and mortgages his house by way of a simple mortgage. He doesn't give up possession, he still lives in his house, but he promises personally to repay the loan. Now if he defaults, the bank cannot just throw him out. The bank must approach the court and only the court can order a sale of the property. That is why it is called a simple mortgage. The remedy lies in a court sale, not possession transfer. In fact, in the case of KES versus K. Ramachandra Reddy 2000, the court made it clear that in a simple mortgage, the mortgagee has no right to possession, only a right to seek sale through court. That is essence of section 58 subsection B. The second type is mortgage by conditional sale. Here the document looks like a sale, but in truth, it is only a mortgage. For example, A takes a loan of rupees 5 lakhs and signs a deed saying, I sell my land to B, but I repay within 3 years, the sale is void. If I don't repay, it becomes absolute. Such transaction is not a real sale, it is only security for repayment. In the landmark case of Pandit Chunchun Jha versus Sheikh Ibadat Ali, the Supreme Court held that whenever there is doubt, courts will lean in favor of treating the transaction as a mortgage rather than a sale. Why? Because the law always protects the borrower's rights of redemption. The right to get back his property. The third type is usufructuary mortgage. Under section 58 subsection B. Here the mortgagor delivers possession of the property to the mortgagee. The mortgagee enjoys the rent and profits instead of interest or loan repayment. There is no personal liability of the mortgagor. For example, A mortgages his orchard to B and give him possession. Every year, B collects fruits and the fruits income towards the repayment of the loan. Importantly, A is not personally liable. B cannot sue A for money. He can only enjoy the income until the debt is satisfied. In Narandas Karsundas versus Essex Kantham, the Supreme Court explained that an usufructuary gives a mortgagee possession and income rights, but not ownership or sale rights. The property still belongs to the mortgagor. English mortgage. The fourth type is the English mortgage under the section 58 subsection E. Here the mortgagor personally promises to repay on a fixed date and transfer his property absolutely to the mortgagee. But remember, this is only conditional. If the loan is clear, the mortgagee is bound to retransfer the property. For instance, when A takes a 20 lakh housing loan from a bank, he executes an English mortgage. The bank gets absolute ownership on paper, but once the loan is repaid, the flat must be given back. In the fifth type is mortgage by deposit of title deeds, also called an equitable mortgage under section 58 subsection F. Here the borrower deposits his property original documents such as the sale deed with the lender intending to create a security. For example, A borrows rupees 50 lakhs from a bank in Mumbai. He gives the bank his flat original title deed without any registered document. An equitable mortgage is created. In United Bank of India versus Lekharam, Sonaram and Company, the Supreme Court held that mere deposit of title deeds with intention to create security is sufficient to create a valid mortgage, and in Rajpal Maharaj versus Bhagwandas Daruka, the court emphasized the intention is key, just handing over the documents casually won't work. This form of mortgage is very common in cities like Mumbai, Chennai and Kolkata because it saves time and avoids registration cost. Anomalous mortgage, section 58 subsection G. Finally, the section 58 subsection G talks about the anomalous mortgage. This is basically a mortgage that doesn't nearly fit into any of the 5 categories we have already seen. For example, A gives possession of his land to B. just like an unsatisfactory mortgage, but at the same time, he also binds himself personally to repay the loan, just like a simple mortgage. Since this mortgage has mixed features, it is called anomalous mortgage. In Bhup Singh versus Ram Singh, the Supreme Court held that when a mortgage combines features of different types, it will be treated as anomalous and the rights of the parties will depend on their agreement on local custom. So anomalous mortgage act as a flexible category to unusual or mixed arrangements. Now let's talk about the registration of mortgages, which is covered under section 59 of the Transfer of Property Act 1882. The rule is simple, except in the case of a mortgage by deposit of title deeds. All other mortgages where the loan amount is above 100 must be created by a registered instrument. This instrument must be signed by the mortgagor and by at least 2 witnesses. If registration is not done, the mortgage is legally invalid and it cannot be enforced in court. For example, in KJ Nantan versus SV Maruti Rao, 1965 SC, the Supreme Court held that when original title deeds are handed over to the lender with the intention of creating security, it is a valid equitable mortgage without registration, but in all other types, registration is mandatory. Now let's look at the rights of the mortgagor, that is the borrower. The most important right is the right of redemption under the section 60. This means that once the mortgagor has repaid the loan, he is entitled to get back the property, recover all the documents and obtain a reconveyance deed. This right is important that the law says it cannot be taken away by any clause in the mortgage deed. In the case of Seth Gangadhar versus Shankarlal, 1958, the Supreme Court held clearly that the right of redemption is absolute. This gave rise to famous principle, once a mortgage, always a mortgage. Section 60A gives the right of partial redemption, meaning if the property is divided and the debt proportionately paid, the mortgagor can redeem his part. 60B gives the mortgagor the right to inspect documents of title that are with the mortgagee. Under section 62, the mortgagor is also entitled to any accessions or improvements made to the property during the mortgage. For example, if the mortgagee builds an additional structure on the land, the mortgagor can claim it after redemption. So overall, the law protects the mortgagor very strongly, ensuring that his ownership is never lost permanently. Now let us move to the rights of the mortgagee, that is the lender. The first and most important right is the section 67, right to foreclosure or sale. This means that if the mortgagor fails to repay, the mortgagor can approach the court and either foreclose the mortgagor's right of redemption or sell the property to recover the loan. But remember, this right cannot be exercised after the mortgagor has already paid back the debt. Next, under section 68, right to sue for mortgage money. Here the mortgagee can personally sue the mortgagor if the mortgagor has bound to himself, sue the mortgagor if the mortgagee has deprived of the security through the mortgagor's wrongful act. Then comes section 69 of power of sale without court intervention. This is a special right available only in certain cases like in English mortgages or when the mortgage deed itself gives such powers. In such cases, the mortgagee can directly sell the property without filing a case. Now, section 70, accession to the mortgage property. If any addition or improvement is made to the property, the mortgagee's security extends to that as well. For example, if a mortgage land later gets a tube well installed, the mortgagee's right to will cover that too. Section 71, renewal of lease. If the mortgage property was under lease and the lease is renewed, the new lease also becomes part of the security in favor of the mortgagee. Under section 72, right to spend money on property. The mortgage can spend money for preservation of property, for payment of government revenue, or even for essential repairs, and the mortgagor has to reimburse these expenses. Finally, section 77, right to receipt of rent and profits. In mortgages, where the possession is delivered like unsatisfactory, the mortgagee is entitled to retain the rents and profit from the property until the debt is satisfied. So in summary, the law balances both sides. While the mortgagor has a strong right of redemption, the mortgagee is also well protected through rights of foreclosure, sale and recovery of money. So friends, today we cover an important topic under the Transfer of Property Act 1882, the law of mortgages. We began with the definition under section 58 subsection A, where we saw that a mortgage is the transfer of an interest and immovable property to secure a debt. We also discussed the essentials of a mortgage and the principle that ownership remains with the mortgagor while the mortgagee only gets a limited interest. Then we studied the types of mortgages under section 58B to section 58G, including simple, unsatisfactory English mortgage by conditional sale and others. After that, we look at the section 59 where we understood the importance of registration for mortgage above ₹100. Next, we examine the rights of mortgagor, especially the rights of redemption under section 60, which is heart of the mortgage, supported by the principle once a mortgage, always a mortgagor. Finally, we turn to the rights of the mortgagee under section 67 to 77, such as the right to foreclosure, right to sale, right to sue for money, mortgage money, and the right to spend money for preservation of the property. So overall, the law tries to balance both parties. The mortgagor is protected by the right of redemption, while the mortgagee is protected by strong rights of the recovery. That was our discussion on mortgage under the Transfer of Property Act. Thank you.
Shubham, thank you very much. It was nice to hear an overview of various sections which are connected with the concept of mortgage, and a nice research you had done in this particular topic. So thank you very much. A small token of Hammurabi to you.
Yeah, thank you.